I'm Calvin Koo, and this is your June 2023 crypto update. As a reminder, my thoughts and comments are strictly my own and not that of my employer. Nothing I say is intended as legal or financial advice. Last month, we discussed regulatory developments in 3 different continents, including the Markets in Crypto Act in the European Union, Hong Kong's encouragement of major traditional banks to accept crypto clients under the existing legal frameworks, and the updated Digital Assets and Registered Exchanges Bill in the Bahamas. I concluded last month's video by mentioning how it was difficult to avoid comparing all these legislative and regulatory developments around the world, specifically designed for virtual assets, against what is happening in the United States, where the primary model has been regulation by enforcement, applying existing non-crypto specific laws. It is there, in the US, that we pick up this month, with 2 high-profile Securities and Exchange Commission, or SEC, actions. Those who follow crypto news specifically, and even global financial news generally, will have seen the headlines that on 5th June, the SEC brought charges against Binance, the world's largest centralized crypto exchange, and the very next day, the SEC brought charges against Coinbase, the largest centralized crypto exchange in the United States. So what's going on here? In today's video, I want to revisit some of the history of enforcement action in the US and the SEC approach to crypto over time. Then we'll review and compare the Binance and Coinbase allegations, followed by a reminder that the US government is not necessarily acting under just one policy goal. First, a look back at the evolution of the US approach to crypto, especially the SEC's approach. Now, ever since government started paying attention to cryptocurrency, they've been asking, what is it? If a government wants to regulate it, and they generally do, how do they classify it in the first place, as that likely impacts how it is regulated? For ease, governments would typically prefer to classify it as something that their laws are already familiar with. For most cryptocurrencies, this means assessing whether they are a security, commodity, derivative, money, or other type of financial product. If it does not fit perfectly within an existing category or laws, then new legislation may be required. So far, there's no global answer and no single US answer either. In the US, many government agencies at the federal and state levels have looked to carve out a piece of the regulatory pie for themselves by finding ways to fit cryptocurrency into existing legal definitions that cause segments of the crypto industry to fall under their remit. By far, the most aggressive agency in the world that is pursuing this angle is the SEC. Now, in response to the initial coin offering, or ICO, boom in 2017, the SEC brought scores of enforcement actions against alleged issuers of crypto tokens. It appears the SEC's focus at that time was to primarily investigate and prevent ICOs based on fraudulent activities, and as a secondary objective, to bring some level of regulation to the industry by alleging claims of unregistered issuance of securities, even where no fraud was found or alleged. It was possible for crypto companies that failed to register to settle with the SEC for multi-million-dollar fines. Sometimes those fines paled in comparison to the amount of money they actually raised. So it could be perceived as a good result for the companies, but also for the SEC as they were making a point about registration requirements. But that type of result for that dollar amount seems very unlikely today. This is because the SEC changed its focus and has taken a more aggressive action since 2020-2021. While this predates the 2022 crash of the crypto market, the SEC's emphasis on these cases and increased resources applied to them substantially grew following the crash in light of headline stories like FTX. This has culminated in the biggest steps the SEC has taken to date, with the enforcement actions against Binance and Coinbase on consecutive days earlier this month. This is an important change in enforcement strategy for the SEC. Rather than focusing on the tens of thousands of potential issuers of cryptocurrency or other tokens, which would be an impractical route to industry-wide regulation, the SEC has instead focused on the largest centralized exchanges through which most cryptocurrency is currently traded. In other words, through this type of enforcement, the SEC can not only regulate, but effectively cut off cryptocurrency trading in the US. This regulation by enforcement approach, which the crypto industry heavily criticizes, is in stark contrast to the approach in other sophisticated financial jurisdictions like Dubai, the EU, Hong Kong, Singapore, and the UK, which have already or are currently enacting specialized cryptocurrency and virtual asset legislation and regulation. So what are the allegations in the Binance and Coinbase cases? There are plenty of other great content providers out there that go through these in detail. But for the purpose of this video, let me focus at a high level, comparing and contrasting the two. Starting with the Binance case, which follows an earlier CFTC, or Commodities Futures and Trading Commission, CFTC action against Binance filed in March, the SEC charged Binance.com, which is the world's largest crypto exchange, and Binance's US affiliate, as well as Binance's founder, with a variety of securities law violations. As noted in the SEC's press release, the SEC alleges that Binance and its founder publicly claimed that US customers were restricted from trading on the global exchange platform. But in reality, the Binance companies and its founder subverted their own controls to secretly allow high-value US customers to continue trading on that platform. And that would be against the US regulations and laws at the time. Further, the SEC alleges that Binance and its founders secretly controlled that US platform's operations behind the scenes, notwithstanding public claims that it was a separate and independent platform for US investors. The SEC also alleged that there was a commingling of customer assets and non-transparent diversion of those assets to related entities, all denied by Binance, all while there was an alleged misleading of investors about what trading controls were in place over the US platform. Now, some commentators believe that these attention-grabbing facts, or allegations, I should say, also portend a potential criminal action by the US Department of Justice. Even in this SEC case, these allegations appear to have laid the groundwork for the SEC to seek a freeze of Binance's US assets pending the legal proceedings. From the SEC's view, there was a real risk of dissipation of assets, which they hoped a freeze would avoid. This was strongly opposed by Binance, and the court ultimately asked the parties to reach a consensual deal, which they reportedly did. After laying out these more attention-grabbing allegations, the SEC press release then focuses on Binance's alleged failure to register as an exchange, broker-dealer, and clearing agency. On this, let me digress for a minute to help those unfamiliar with how traditional securities trading works. Now, there are three types of entities involved in securities trading. You need the stock exchange, which is the marketplace where buyers and sellers can match. You need a broker, who acts on behalf of a buyer or seller in those transactions, and need the clearinghouse that affects those trades as a trusted middleman. License and registration is needed for each of those services under the securities laws. But in the case of crypto, these large global crypto exchanges arguably operate in all three roles, taking advantage of blockchain technology for efficiency, among other things. Now, this is one area where crypto advocates say that the traditional securities laws just don't fit well into the reality of modern blockchain technology. Notably, this issue also applies to the Coinbase scenario, so let's turn to that. There, the SEC also alleged that Coinbase failed to register as an exchange, a broker, and a clearing agency. However, the Coinbase complaint lacks any of the headline-grabbing allegations of misleading investors about trading controls or misrepresentations about parent company control over affiliates. There's no allegation of potential asset misuse or diversion, and no application to freeze assets. Instead, it's a pretty straightforward failure to register case from the SEC's perspective. Coinbase and its supporters will point to the irony or contradiction that Coinbase is listed as a company in the US, and as such, it strikes them as odd that the SEC can, on the one hand, approve of Coinbase's business model when Coinbase got listed in 2021, and yet now is accusing Coinbase of securities law registration violations. No doubt we'll see how Coinbase and the SEC argue this point in the wider case as the matter progresses. Another key commonality in the Binance and Coinbase enforcement actions, which have wider industry implications, is that the SEC identified several tokens it considered were securities after setting out its Howey test analysis, such as Cardano, Polygon, and Solana. In other words, the SEC used US case precedent based on this old case called Howey to determine whether certain crypto tokens exchanged on Binance and Coinbase should be deemed as securities under American securities law. As we said before in this series, whether crypto tokens are securities is a novel area of law that is still developing. Nevertheless, the SEC had to conclude in these complaints that there were securities being exchanged, brokered, and cleared on these platforms because it could not otherwise pursue a claim that Binance and Coinbase were operating as an unregistered exchange, broker-dealer, and clearinghouse. One criticism of this approach is that the entities behind those purported securities are not defendants in this or any other SEC action currently, meaning they have not had the opportunity to litigate the question of whether the tokens that they issued are actually securities. Most likely, those entities would argue they are not. This is because most token issuers and the various industry facilitators like exchanges reject the notion that most tokens are securities, which of course would then bring it under the remit of securities laws. Typically, their view is that at best, these are commodities like gold or are akin to luxury products or collectibles. At minimum, as I noted a moment ago, they say that securities laws that were developed in the 1930s and 40s cannot reasonably apply to novel technology behind cryptocurrency, with its distinct features that are incompatible with analogies to traditional finance. Therefore, many prefer new legislation and rulemaking over regulation by enforcement. One final point about the SEC's approach. As I've said before in this series, the US government is not a monolith. Even putting aside the various state-level officials and agencies, even the US federal government is not a monolith. So, for example, a comment that the US is anti-crypto is not strictly accurate. While the SEC currently appears to have a very strong negative view, there are dissenting SEC commissioners to their regulation by enforcement approach, meaning other leadership in the SEC disagree with what the rest of the SEC is doing. Moreover, the CFTC, the commodities regulator, states that all virtual currencies are commodities, which arguably is a position inconsistent with the SEC's view that most crypto tokens are securities. Now, the CFTC has also pursued crypto enforcement cases under commodities laws, but it's perceived generally as being less aggressive. Finally, various members of Congress hold extremely divergent views on the appropriate way forward with crypto, with some House Republicans, for example, in Congress recently proposing the Digital Asset Market Structures Bill. Now, early response from crypto supporters has generally been positive for this bill that looks to clarify regulatory responsibilities over virtual assets in the US, particularly as between the SEC and the CFTC. It also looks to provide a clearer path towards SEC registration, taking into account the unique features of this modern technology. The path from bill to law is a long one, and this is still just at the very beginning of the process. So it may still take a year or two for this to finalize, if at all. And the SEC enforcement actions will continue in parallel in the meantime. So to summarize, many sophisticated financial jurisdictions around the world are taking actual or at least perceived concrete steps towards legislative and regulatory clarity over virtual assets. But the US is seen as being a laggard. Although the US government approach isn't a monolithic one with diverse views, the SEC is certainly taking the most noticeable and active steps right now, continuing its regulation by enforcement approach. That approach has evolved over time from targeting issuers of tokens to now bringing major cases against the world's largest exchange and America's largest exchange. If the SEC succeeds, some say that could effectively cut the US market out of crypto in many ways, all while the rest of the world finds a way to integrate it. Crypto watchers eagerly await to see how these cases turn out and whether crypto legislation advances in the US Congress. In both cases, these will play out over the coming 1 to 3 years or so. That's it for this month. I'll see you next time.